we're dealing with family issues, we have a litigious family member, we can also use these entities to eliminate, with someone coming in trying to take charge. It's not uncommon for clients with larger families especially to have one child that thinks that they ought to be in charge. So we got one, for instance, with some timberland, and if we just had assets go directly out to them, this one here is going to have an equal voice with this one over here. It's not going to be majority rules or anything else. Any one of them has the power to force a partition or a sale of the property. They can wreak havoc of things. If instead, though, we have that timber interest going into an LLC, LLC interests go equally to the kids, but reasonable child that we want to be in charge is named manager of that by the trustee. The child that would want to sell, the child that would want to be in charge, the child that would want to partition the property would have no rights to do any of that. All he has is a non-voting membership interest in LLC that when the responsible child decides to sell, the unreasonable child is going to get his share of the proceeds, but he can't come in and create those issues and get into those judicial rights. That's the type of thing we can do inside of these entities and give creditor protection as well. So we can do all of those things. Discounting I'm not going to talk a whole lot about. Oh, this is an exciting section here. All right, so I'm going to leave the traditional self-settled or third-party settled trust now and leave the LLCs and things. Anybody have any questions on LLCs or limited partnerships, by the way? We're going to leave that a little bit and move now to an area that a lot of you may not be familiar with or heard of, and that is there's an IRA trust or inheritance trust for retirement assets, a retirement preservation trust. And it's not a new concept, but it hasn't been very well publicized. But there's kind of new life that's been breathed into these things because of a Supreme Court case that came down last year. These are known by a number of different names: a standalone beneficiary trust, a retirement plan beneficiary trust, an IRA trust, a retirement preservation trust is what we generally call them, or an IRA inheritance trust. All means the same thing. It's a trust designed to be the beneficiary of a qualified retirement account. And so we can have that qualified money roll into a trust rather than go into an individual, and the grantor then can retain a lot of dead hand control over what happens to those assets. Sometimes it's because they want to retain dead hand control. Other times it's because we want to provide creditor protection, and we'll talk about that. These things originated because it's permitted under the final regulations that came out in 2003. So these things have been permitted for a while. By 2005, we had private letter rulings that approved these things. So we know that they work. We know that the service accepts them. They can be done through revocable trust or irrevocable trust. The only rule is it has to be irrevocable at the time of death. And so as long as you've got a revocable trust that turns into an irrevocable trust at death, you don't have an issue. Now, typically in my office, we will create it as an irrevocable trust to begin with rather than revocable, because there's a bad decision in Kansas where the court reasoned that, well, revocable trusts are subject to creditor claims, and since at the time of death it was a revocable trust, I'm going to let the creditor have access to the assets in the revocable trust at death, and that's the retirement assets got slammed in there. So we make them irrevocable from the beginning. They're not going to get funded till death anyway. So if we want to make a change, we just do a new trust and call it retirement trust number 2 and never fund trust 1. So it's effectively the same as a revocable trust without the risk of that Kansas case. But qualified retirement plans can be made beneficiaries of it, and the trust is drafted in a way that it doesn't disqualify the assets from stretch out. And that's the thing we want to avoid, right? We don't want to be under the 5-year rule. We want to be able to stretch this out over the lifetime of the beneficiary. And so who should consider these things? Well, anybody with a substantial retirement account ought to give some consideration to these for a couple of different reasons. The two only reasons, stretch out and preservation or protection of the assets. Stretch out because if we name a beneficiary directly, certainly they have the right to stretch that out, right? The smart thing for them to do, the thing that we're always going to advise them to do, is to elect by December 31st of the year following date of death to take it out over your life expectancy. And we're going to look at that table then, and we're going to take a little bit out this year and a little bit more next year and a little bit more next year. But the rest of that money is going to grow tax deferred inside of this account, inside of the inherited IRA account, and grow much more rapidly than this money's coming out, right? Except what happens when the child gets the inherited IRA account. Do they stretch it out? No. Even though we tell them that they should, and even though they have good intentions of doing it, they need a new car, and they want to buy another house and a swimming pool. And pretty soon, because the ability to stretch out doesn't mean the limitation of only taking the required distribution, it's going to take the discipline of the individual not to exceed that because they have every right to.
Speaking of required distribution in traditional, you have to start taking 70 and a half.
Yes.
What about a Roth?
You do not for your own. For an inherited, you do. But for Roth, for your own Roth, you do not. Doesn't have a required distribution. That's right.
Somebody, I was thinking it did, but I wasn't sure.
Yep.
You said substantial amount of money in the retirement plan. How much is substantial?
Well, if they got over $150,000 in there, I think it's worth the conversation. Depending on, if they're dividing that by 5 kids, no. But if I got $150,000 going to one person or so, it's worth having a conversation. Certainly if they got $250,000, because when you start looking at, the ability to stretch that out over life expectancy of that child, and the child's relatively young, or even better, we're going to skip them and go to grandchildren, now you're looking at huge dollars that this money could grow into, and you're basically making that child or grandchild a millionaire, or sometimes multimillionaire, simply by virtue of the magic of compounding interest. So I think it's worth the conversation. Certainly clients with more than $500,000, to me it's a no-brainer for them to do this. Now I say that, I've got a client, we're doing substantial planning for them, with asset protection planning and lifetime gifting planning and such. And this client has about $1 million in an IRA. And I said, look, we really ought to take this money and move it over here in one of these trusts. And there's 2 children, so it's, $500,000 apiece. It's going to be substantial money, and the children are relatively young. And so, well, I don't worry about that because we'll probably spend all that by the time we die. But they've been so conservative, that's why they got $1 million in there to begin with. They're not going to spend it. Some clients aren't receptive to it, but it's a conversation we have with them, at about $150,000 level, just to begin the conversation with them. And when you demo it out, it gets pretty substantial. By putting into a trust, we're not relying on happenstance or discipline of the child to do the smart thing and stretch it. We can force the stretch out because we can limit the trust. The trust is the owner. The trust can say, we're not distributing anything except the required distribution, and nothing else comes out. It stays in trust, going to be invested, reinvested, compounding up until you reach age 65 or age 70 or something like that. And so you can force that discipline on them with that and force that stretch out. The other piece to it, and that's really what's becoming more important now, is protection of the assets. The traditional rule in most states, including Mississippi, retirement assets are creditor exempt. So we're not subject to creditor claims and bankruptcy and such as that for our own retirement account. The question that's been kind of flipping around there for the last 10 years or so is, what about if it's an inherited retirement account? If I receive an inherited IRA from my father and I get sued, have to go to bankruptcy, is that also an IRA? Is that also a retirement account? It says on there, inherited individual retirement account. And some states were saying, no, that's not a retirement account. That's inherited money, and so that falls in different rules. Other states were saying, yeah, it says retirement. That's a retirement account. The United States Supreme Court weighed in a case called Ramaker of the Stretchout and have a substantial asset in trust, in a protected trust, not subject to their creditor claims, and hopefully can provide great retirement assets down the road. So what kind of protections can we get? Lawsuit protection, third-party creditors, divorce protection. You're not going to be subject to a creditor claim. It's in a trust like that. Not going to be subject to a QDRO order, domestic relations order. It's not. You're not going to be subject to that. It's not going to ever be marital property. Protection from Medicaid. Again, not every state exempts retirement assets. By the same reasoning of the Supreme Court's case, even if you had an exemption of the state for retirement assets, if it's an inherited retirement asset, it probably, at least arguably, wouldn't be subject to that retirement exemption. And so it might be an available resource. Because again, Medicaid wants to count whatever you've got access to, Medicaid generally can count as an available resource. If it's in this trust, though, the trust will be drafted in such a way you don't have direct access to it and not going to be an accountable resource for purposes of Medicaid qualification. estate taxes. We can even have a trust like that outside of taxable estate if we wanted to design it properly. So a lot of different protections that can do it. But the biggest issue that again is come up is this Clark versus Ramaker decision, and that to me is probably the biggest the biggest argument now for large retirement accounts going into one of these trusts, even if you don't want to force stretch out. I mean, I've got clients that say, well, it'd be nice if my kids stretched it out, but if they really need the money, I'm okay with them taking it early. And so we won't necessarily design the trust where it can only pay required distributions and nothing else because they're okay with it paying more than that. But if they get sued, we don't want that asset being subject to that claim, so we don't want to leave it directly to the child. We throw it into this trust, and now the assets can accumulate inside that trust, not be subject to those creditor claims. So we get by the Clark versus Ramaker decision and the fallout that's going to come from that now nationally. So it's a really good option. So comparing that to if you give it directly to individuals, maybe they stretch it out, maybe they don't, but they have no protection over it now under current rules. If we have it payable to a living trust, like the Bill and Mary Trust that we started our conversation with an hour and a half ago, stretch out, if the trust is designed properly, we can get stretch out because that trust can qualify as a qualified beneficiary. Now, a lot of them floating around there don't because they don't have the right language in it, but they can. Do you get any protection over those assets inside of the living trust? Depending again on how it's drafted, this says yes, but it really should say maybe. Again, it depends on how it's drafted. If it's too closely available, it's not going to be protected. If you have it in a separate IRA trust, though, you now have total control over that. It's not you can have controls over the stretch out protection, and you can get absolute protection over those assets. From third-party creditors as well. The IRS has approved them multiple times, and so we know how to draft them. Now we as lawyers know how to draft them where they get stretch out, where they get protection, and where we can even get individual stretch out based on the individual ages of multiple beneficiaries. And so we can do all of those things and have PLRs that back it out. Ran some numbers. Actually, I didn't run them. Bob Keebler ran some numbers, kind of illustrate some of these the stretch out concept. And so you got parent age 65 that's going to die at age 84. Children age 35 going to die at age 84, and they hadn't had their kids yet. Their kids are going to be born 5 years later, so we got a -5 age there that die at age 84, with a growth rate, pre-tax growth rate of 6% inside an IRA of $250,000. If we make the assumption that money's not, even distributions are not going to be spent, so we have distributions come out, and we're going to save those distributions as well. How much money do we wind up with? If we wind up forcing a stretch out of that IRA, over the course then of the kid's life, we're looking at that $250,000 IRA being worth $10 million at the end of their life. So, a substantial, not outrageous growth rates either at 6%. It's just compounding money over that length of time. If we skip the kids and make the grandkids the beneficiary, though, looking at $13 million. And so that's why I say, if they have even $150,000, it's worth having this conversation, because if the kids are relatively young or they're willing to skip the kids and drop down to the young grandkids with that, you're looking at the opportunity for substantial growth of assets. And so certainly that kind of money becomes a target for people that might sue you and such. And so it makes sense to have both protection, and again, it's not going to happen if they have the ability to pull it out. So what you want to do is limit their ability to pull it out, and only have the required distributions come out at best. So clients have now an opportunity for generational trusts that can provide a huge benefit. A lot of advisors, I find, just don't realize that option's out there. So that's why I kind of like to spread the word whenever I have opportunity to do this.